The door and walk in.
Ta-da.
Hear ye, hear ye, hear ye. All persons have anything to do before the Honorable Justice of the Appeals Court, now sitting in Boston within for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
No.
Good morning. Welcome to the Appeals Court. Guess everybody's here for the cases today. All kidding aside, I'd like to welcome everyone, current judges of the Appeals Court. I see some of our retired colleagues here in the audience today, many staff members, counsel, and other guests. And most importantly, I see Judge Tan's husband, Greg Schwartz, and I'm also told, I'm going to scan the audience, that there he is, Judge George is from the SJC. Welcome. Thank you all for coming today. Two people that are not here today are Judge Tan's daughters, Emily and Sarah. As you'll hear, Judge Tan was a juvenile court judge, so they're in school today so that we don't end up with a child in need of services petition in the juvenile court this afternoon. It is a great pleasure to welcome one of our newest members of the Appeals Court, Justice Gloria Tan. Judge Tan was nominated by Governor Healy and confirmed unanimously by the Governor's Council and was sworn in a private ceremony a couple of weeks ago. Joining me on the bench today, in addition to Justice Tan, is our Senior Justice, Ariane Vuono, Justice William Meade, and Justice Rachel Hershfang. By tradition, the Appeals Court employs an expanded panel of 5 judges for the first case heard by a new member of the court on the occasion of their very first sitting. After the first case, the panel will reconstitute, and I will be joined by Justice Hershfang and Justice Tan for the second case. A little bit of background about Justice Tan. She grew up in Texas. We won't hold that against you. She graduated from Rice University, magna cum laude, and as a member of Phi Beta Kappa. She earned her JD from Yale Law School. As we say in Boston, she's wicked smart. Judge Tan began her career as a public defender representing juvenile and adult clients in the Youth Advocacy Project and Boston Trial Unit of the Committee for Public Counsel Services. She then served as the Deputy Director at Harvard Law School's Criminal Justice Institute, where she taught and supervised law students representing indigent adults and youth in criminal and delinquency proceedings in Boston. In 2013, Judge Tan was appointed to the Juvenile Court, where she eventually became the first justice of the Middlesex County Juvenile Court. She was also the recipient of the Massachusetts Bar Association Access to Justice Award. Judge Tan has served on a number of committees, including the Trial Court Standing Committee on Alternative Dispute Resolution, the SJC Committee on Jury Management, and is a board member and executive committee member of the Flashner Judicial Institute. She is also a mentor and advisory committee member of the Trial Court Judge-to-Judge Peer Mentoring Program. As you can see, Judge Tan has left her mark on the judiciary and the broader legal community, and we're sure she will continue to do so here at the Appeals Court. Here we do follow a custom used in the Superior Court of numbering our judicial seats. Justice Tan, you are now the third person to hold seat 19. That seat was first held by Judge Gordon Dorfer and then most recently by Justice Gabrielle Wolohojian. I must say you have a very special seat. I should also note that counting all statutory and recall judges, you are the 84th person to serve as a justice of this court. So I'm thinking your husband should play the lottery number 19884 today. I will now ask our clerk of court, Paul Tuttle, to read your judicial commission.
To all to whom these presents shall come, greetings. Know ye that we, by our governor, with the advice and consent of our council, confiding in the ability, discretion, and integrity of Gloria Yenfun Tan of Newton, do hereby, under the provisions of Chapter 211A of the General Laws, as most recently amended, and in conformity with our Constitution, constitute and appoint her to be an Associate Justice of the Appeals Court, to hold said trust during her good behavior therein, unless removed therefrom in the manner provided by our Constitution. And we do authorize and enjoin her, the said Gloria Hershfang Tan, to execute and perform all the duties, and she is invested with all the powers and responsibilities which by our Constitution and laws do or may pertain to the said office, so long as she shall hold the same by virtue of these presents. Witness Her Excellency Mara T. Healy, our Governor, and our Great Seal hereunto affixed at Boston this 18th day of December in the year of our Lord, 2024, and of the independence of the United States, 247.
Congratulations, Justice Tan. I actually want to recognize one other person. Justice Coyne from the Juvenile Court has joined us. Justice Coyne, thank you for being here. That concludes our official induction of Judge Tan to the Appeals Court. We will pause for a brief moment. For those of you present for the induction only, I don't know why you wouldn't want to stay for the rest of the cases, but if you wish to leave, you may do so now, and then I will call the first case.
Please.
Oh, yeah, my lunch. I left my lunch.
Why don't you give it to one of the court officers?
What do you? Oh, your lunch.
Dana, could you grab that from Judge Hanson? Thanks. Is he staying?
What's he doing? Oh, nice. GP or? Okay. Oh.
I'm gonna stay.
Yeah.
That's right, nice. Well, you cleared the courtroom there.
Uh-huh. He's got nothing to do.
Thank you.
It is embarrassing when you're being talked about, but it's important. Absolutely. All right, I think we can actually do some work now. And I know that you have been here before, but just very briefly for the record, each side is permitted 15 minutes of oral argument. There is no rebuttal. I can assure you that we have read your briefs and the appendix, so we know the issues. You should get right to your argument. With that said, I will call our first case, which is Commonwealth versus GERARD. I'm sorry if I mispronounce this, DIVENUTI Jr., docket number 24P558. Attorney Weber, good morning.
Good morning, Your Honor. Thank you. And at least as far as I'm aware, that is the correct pronunciation.
Okay.
Mr. DIVENUTI's case is here today because the motion to suppress should have been granted as there was a lack of probable cause. Now, as Your Honors are aware, the police showed up to this home in order to arrest Mr. DIVENUTI for warrant unrelated to the current case. And I will say the home because it certainly wasn't his home. Now, it seems in the Commonwealth in their opposition brief seems to concede that issue, but I was certainly a live issue during the suppression hearing. So in regards to that, it seems to me at least and very clear that it wasn't his home. I mean, there was really nothing other than his presence there alone that could indicate it actually was his home.
Excuse me, why does it matter? I mean, they serve an arrest warrant, they find him there, he's in possession of drugs that are consistent with an amount for distribution. There's one of the implements of the drug trade, the scale is there. We're talking about probable cause just to search the apartment.
Well, it's not completely dispositive of the issue, but I think it is at least relevant because part of the police office reasoning in their application for the search warrant is thinking, well, this is a drug dealer. We're trying to find his drug stash that he keeps in his home.
I mean, and that would be relevant if you were challenging the sufficiency of the evidence for constructive possession, but you're not.
Well, I would just argue that in regards to whether or not it's his home, there's certainly this element of what is more likely for a drug dealer, to keep their drug stash in their own home or to keep it in someone else's home. Now, I certainly not going to say it's impossible for it to be kept somewhere other than their own home, but it is much more likely that they would be keeping their drug stash in their own home as opposed to
Well,
their
it's his girlfriend's home, right?
I apologize.
His girlfriend's home?
Yes, Your Honor, his girlfriend's home. So I would at least argue that it's at least is part of the calculus. I think if it was his home, it would be more likely that he would keep his drugs there. But even if we go beyond the issue of whether or not he lives there, even without that, there is certainly not sufficient evidence for probable cause. Your Honor referred to the weight of the drugs. Now, there's things referred to in the Commonwealth in their opposition refers to, it being an amount sufficient for trafficking, but their references that are actually from the trial transcript and not from the suppression hearing. So I would argue that.
But it was packaged, though, in several different bags, right?
In several different bags, yes. But I would say in regards to the amount, the overall weight, because in fact, at one point during the suppression hearing, there was a statement, admittedly by defense counsel, but even so, states it wasn't trafficking weight, so you could draw an inference from that. Nobody reacts in any way. There was no challenge to the idea that it wasn't trafficking weight. So from the indications we have on the record, and there was nothing in the record, at least in the suppression hearing, about the specific weight. The specific weight wasn't in the affidavit in support of the search warrant. In fact, the only thing we have is that statement that no one responds to, no one seems to say, oh, no, actually it wasn't. This was a statement that was made as if it was just obvious to the court. So I would say,
Go ahead, I'm sorry.
But on that issue of weight, though, I mean, really, they're packaged, they're individually packaged, and they're in different denominations as well, right? Whether it's trafficking weight or not, there's still evidence, right, based on the detective's, statements in the affidavit and his training and experience, investigating drug transactions, that the individually packaged, specifically different denominations, would be consistent with drug dealing, correct?
I mean, it is packaged in a way that a drug dealer would package it. I'm not arguing otherwise in that regard, but we are talking about crack cocaine. This is not something that a person's going to purchase at the corner store. They're not getting CVS. They would buy it from a drug dealer. So the idea that it's packaged in a way that a drug dealer packages it, well, it comes from a drug dealer. So of course it's packaged that way. So that could mean that when Mr. DIVENUTI purchased it, he didn't repackage it himself, or the drug dealer he purchased it from didn't have the exact perfect amount in a perfect
There are multiple bags packed together and with different amounts in them, and they're all contained in a single larger bag.
That is correct, Your Honor, which I would say that just means that someone packaged it in a manner consistent with what a drug dealer would package as, but that could just as easily mean that he bought it from a drug dealer and
That's one conclusion that the magistrate could have drawn from the affidavit, but that the police don't have to exclude hypotheses of innocence to establish probable cause.
They don't have to exclude hypotheses, but they still have to have enough. And the idea just that, because you have the way it was packaged, but really outside of the way it was packaged, there's, as I would say, very little else that would
Scale.
And I certainly was going to address the scale, Your Honor, because obviously that is the other thing. That scale, the digital scale, where it was found, I would say, is quite significant. It was found in the kitchen. Now, a digital scale, as Your Honors are aware, is not an inherently illegal device. It is something that actually is quite easily obtainable in a variety of locations, used very often cooking and baking. And
You use a digital scale for cooking and baking?
Yes, Your Honor, actually, because at least my wife is more of a baker than I am. I admit I'm more of the cook, she's more of the baker. But when you are baking, there are very much recipes that you need to be down to the gram. That is very much
But the
a
point
reason
here
that
is-
digital scales are used.
Hold on a second, I don't think I have any sound. That's all right. But the point here is not that the digital scale could be used for other things. The point is that the officer here who wrote the affidavit, based on his training experience, said that it is a kind of scale, and it is an instrument of drug trafficking, of drug distribution.
Well, for that, I would cite to the Landry case, which I do have cited in my brief. While the possession of an item in a setting inconsistent with legitimate use could ordinarily establish probable cause, the inference cannot be made when it's found in a setting consistent with legitimate use. And that's what we have here. The scale was found in the kitchen. That is where a scale would be found. That is in a setting consistent with a legitimate use. And there's no notation about there being any kind of drug residue or any kind of powder on the scale. So as far as we're aware, this is a clean scale. Now, obviously, if anyone can clean a scale, even a drug dealer can clean a scale, but then we would have to assume that they cleaned the scale but left it sitting out on the counter for anyone to see. The kind of drug dealer who's meticulous enough to clean the scale after every use.
It was 6 a.m.
6 a.m., if anything, I think that would indicate even more so that person wouldn't have taken the time to have set up and cleaned everything. Just to the point that there's nothing about the scale in and of itself, because it is found very much in a setting that is consistent with its legitimate use, because it is indeed a scale, something that is very often used for baking. And the scale really in and of itself, I'd say, the scale and obviously the actual drugs itself, because outside of that, there's actually, I would say nothing that really supports the search warrant. The Commonwealth also refers to in their brief an amount of cash, $490, that was found. However, that is also a reference to the trial transcript. There's nothing in the affidavit in support of the search warrant that references cash. There's nothing in the suppression hearing that references cash. So I would argue that that shouldn't even be considered in regards to the calculus.
Counsel, on that point, though, in terms of, you state in your brief that the homeowner came home and told the police about the backpacks. There's a backpack and a blue bag behind the TV that belonged to the defendant. But that also was not in the affidavit either, right? So that's not something that we should consider either?
I believe it's at least in the suppression hearing, but regardless of the reference to that, honestly, those statements, because those items belong to the defendant. I don't think anyone's challenging that those two bags were the defendant's bags. So
But you make an argument, though, in your brief that those two bags go to show that if he actually lived there, it'd be more than just two bags.
Correct, Your Honor. That was part of the reasoning in regards to that. I believe at the very minimum those bags were mentioned in the suppression hearing, so at the very least it was something that the judge heard during the suppression hearing to be able to consider in regards to making the decision, and something that the judge could have considered in the suppression hearing when it came to whether or not that is something that, whether or not the defendant lived there or not, in regards to the overall decision. And also there's and beyond that, there's also the observation the police make note of a green leafy substance that they say appears to be marijuana. However, this situation took place well after Massachusetts had legalized marijuana. So I would argue that the observation of marijuana in the house is essentially akin to seeing a bottle of vodka.
It's still illegal to distribute marijuana without a license.
There was no indication that the marijuana was in an amount that, so there's nothing about the specific amount of marijuana. So we don't know what the amount is, but as we don't know what the amount is, I think it would be a jump to just go to the idea that it was enough marijuana to be there for distribution. Because if it's not there for distribution, then as stated, it would just be it's equivalent to finding alcohol. At the same time that a person is not allowed to sell alcohol unless they have a liquor license, but if some police come into a home and they see 5 bottles of vodka sitting on a counter, I think it would be quite a stretch to say, oh, well, this person must be selling alcohol without a valid liquor license. I think that would be quite a jump. It's essentially what we have is marijuana that could have just very easily been purchased from a dispensary, something that at that point was legal. So beyond that, even the search warrant also references the fact that Mr. DIVENUTI, when he answered the door and saw the police, kind of backed into the apartment and went to close the door, which I'm certain that could be seen as him being nervous about a police encounter, but considering there was indeed an arrest warrant out for him for, well, actually, the record's not clear what the arrest warrant is out for, but I think it's quite reasonable to think that he knew he had trouble with the law, and he saw the police, and that's simply just a reaction of, oh no, I'm going to get arrested, so he goes to close the door. I don't think that shows anything beyond just that he's someone who
knew the police were there to arrest him, or just in general.
Well, but we do know what the arrest warrant's for. It's in the affidavit. One was malicious destruction, one was A and B, but one was Class A.
Oh, my apologies, Your Honor, that I misremembered the specific reason for it, but even so, that I would say that wouldn't really add anything overall, because the fact that there is a possession A in there, if we were to say that a search warrant could be granted on that, then that would essentially just go to the idea of once you have a criminal record of any kind, that it would then just allow them to get probable cause on the
I
basis.
think what you're doing, and I understand why, is isolating individual facts, right? But we're looking at the totality of the facts contained within the search warrant. And I agree, we could point to any one particular fact and say that's insufficient, but we've got to look at them as a whole.
And I would argue, even looking at them as a whole, we don't have sufficient probable cause. I mean, obviously, I break them down piece by piece because, well, I'm not sure of any other real way to analyze the entire situation than to go through it piece by piece. But even after you go through it piece by piece and then put it all back together again, ultimately, what you have is a person who had drugs on them, which, as stated, the record is not clear, and I think, if anything, would indicate that it's not a sufficient weight for trafficking. So you have someone who has some drugs on him that is packaged in a way a drug dealer would package them.
Does the affidavit say that it was sufficient for distribution or consistent with distribution?
Not in terms of weight, Your Honor, no. It just refers to the way it was packaged, the manner, but not in terms
Was
of the
consistent
weight.
with distribution?
Well, they would say in terms of it was packaged in a way, the affidavit states that it's packaged in a way a drug dealer would package it, which certainly I would say it would indicate
So it doesn't
distribution.
have to be trafficking to be a drug dealer.
Well, no, I'm sorry. I don't mean to say it necessarily has to be trafficking, just in terms of possession with intent to sell. Yes, I didn't mean to split hairs over whether it's trafficking or a possession with intent. But regardless, the weight is not sufficient, at least from what we have in the record, to show that it was indeed possession with intent or in that regard. So you have drugs that were packaged in a way that a drug dealer might package them, which when someone's buying illegal drugs, that's not exactly anything that's far-fetched, and a digital scale located in a location that is consistent with a legitimate use. I would argue.
And at 6:15 in the morning, and the defendant is alone in the space with a 13-year-old child, right? So when you say there's not, first of all, I agree with Justice Meade's earlier question. It doesn't really matter if he lives there or not. That's a little bit of a red herring, and I don't understand you to be saying he needs to live there in order for the warrant to be allowed. But he's someone who has been entrusted with this home and this child at a very early hour in the morning. Were the police, was the magistrate allowed to consider those things as well in terms of the defendant's connection to this space?
I mean, the only thing, if we are saying that it doesn't matter if he lives there or doesn't live there, then I would say the hour doesn't matter, because the only thing that the hour goes to is whether or not he lives there. There's certainly nothing about someone's.
No, but people have relationships to spaces that they don't live in, but where nonetheless they leave things and they store things and they spend time, and right? I mean, he wouldn't necessarily have to live at a storage unit that he had rented for the purpose of keeping his drug stash there if that was where he decided to keep his drug stash.
Well, and then that point to the fact that this is the only time there's any notation of him being at this location. There's
So how did the cops know to go there at 6:15 in the morning?
To be honest, Your Honor, I'm not certain, and that's something I've been asking myself as well, but unfortunately, I can only go by what's on the record, and the record is not clear as to why they knew to go to that location. But it certainly is.
But they did, and there he was.
Yes, Your Honor, they did seem to find him at that location, but ultimately, just seeing that my time is just saying that the time in the morning only would go to whether or not he lives there. Otherwise, or whether or not, I suppose, the connection to the location. An early time in the morning doesn't mean he's more likely to have drugs there. So unless there's any.
Let me just check to make sure. I don't see any other questions. Counsel, I do need you to file a revised appendix because your client's social security number and date of birth are still in the affidavit and not redacted at record 43. So if you could do that within the next day or so.
Certainly, Your Honor.
Commonwealth?
Good morning. May it please the court, Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Just to clear up a couple of things, the affidavit did not mention cash being found on the defendant. It did not mention weights. That did all come out at trial, and there's a separate part of my brief where I summarize the evidence at trial, and I don't think I mixed them up. If I did, I apologize. I'm not sure this is even a probable cause case. I think it's a nexus case. Nexus is part of probable cause. The question is whether evidence of the defendant's drug activity would be found in this place at this time. And the defendant had an active warrant on a drug-related charge, so probable cause had been found that he was connected to drugs. He is in the apartment at 6:15 in the morning, alone with the owner's 13-year-old child. The affidavit does not say that she's his girlfriend, but I think there's an inference that they are at least connected enough that the resident of the apartment, it trusts him enough to leave him with her child. He is confident enough there and at home enough to open the door when the police knock. He does not want the police to come in. Inferentially, he does not want them to see what's inside. He has drugs on his person consistent with distribution.
Before we get there, what's the best case or the most factually analogous case in terms of he doesn't live there, but he's got this sort of access to the home?
I think it's Andre Fields, 98 Mass App Court 475. It's a recent case. There is, well, the defendant appears to have, certain legal connections to one place and certain, I forget whether they were social or certain other connections to a different place. And the court in Andre Fields, it's cited in my brief, says the fact that he did not legally or permanently live in the place where the police got the warrant to search doesn't mean that you could not find drugs there. It's kind of an inverse of the other proposition that we're always arguing, that the mere fact that he lives there isn't by itself enough. The mere fact that he doesn't live there is also by itself not enough to eliminate that location as a place where evidence might be found. Andre Fields cites another case, and I don't have the embedded site, but it's in Andre Fields. Whether the suspect owns the premises, lives there, or merely conducts business there, the question is whether evidence is likely to be found there. And again, we take it all together. Taken all together, no one piece of this is sufficient, except that the drugs in the pockets certainly tell us that's certainly probable cause that he is involved in distribution of crack cocaine.
But if he had been stopped, let's say the police went out at 6:15 and they saw him actually leaving the building and going to Dunkin' Donuts, right, and they approached him in Dunkin' Donuts and he had the drugs in his pocket. That certainly wouldn't be probable cause to search Dunkin' Donuts.
No, by itself, no.
Right. So the drugs on him has to do with him, not necessarily with the space that he's in.
Exactly. But given what's on him and everything else that we have seen about the scenario, that the police knew that he would be there, that he was there, that the scale is there, that the scale has an innocent purpose, I just level the cup with the knife, but that probably explains a lot
It's
about
really
how my baking turns
life-changing
out.
to get the scale, I have to say.
I have been told this. I think it like that explains why my brownies turn out the way they do. But again, we don't have to disprove, even at trial, even if we were looking at a sufficiency argument after trial, we don't have to disprove hypotheses of innocence. And we certainly don't at the probable cause stage.
I didn't see any information either in the affidavit in support of the warrant or in the warrant return about the quantity of weed that was in that bag. Did I miss that?
I don't think so, and I'm trying to remember now whether there was even any testimony about that
It seems like if it had been a distribution weight quantity, that would have helped.
If it had been, like it says it was in a clear plastic
Right,
bag.
but it could have been a dime bag for all we know, right?
And given that marijuana is legal at this point, I don't think that's a crucial part of of the probable cause analysis. I mean, it is simply another piece of evidence, but I don't think it, and, you know, maybe the analogy to the 5 bottles of
And he
vodka is
wasn't
a
charged
good
with
one.
marijuana. He was only charged with
He wasn't
cocaine.
charged with marijuana, no. Well, I don't, yeah, because I don't think there was any evidence he was distributing it.
Possession with intent B only.
Right, and the
And the
methamphetamine that they found everywhere else in the apartment. So, but, you know, even if this court were to find that there wasn't probable cause for the search, which means that the guns and the methamphetamine need to be suppressed, there is still that cocaine in his pocket, and there's absolutely no reason to touch any possession with intent on the cocaine. If there are no further questions, I will rely on my brief and ask this court to
panel?
affirm the judgment.
Seeing none, the matter is under advisement. Counsel, thank you both for excellent arguments.
Thank you.
We are going to take a very brief recess to reconstitute the panel, and we will return to